Welcome back to the Data Protection Diaries. Welcome back to the vlog. This week has been a very busy week, which is why you are joined back in the living room rather than back in the office. And we're filming this video on a Sunday morning, ready to go out tonight because we just didn't have time to do it this week. This week, we are primarily looking at the news that's come out again around the Facebook data transfer issues since the bringing down of the Privacy Shield in the European Court of Justice earlier this year. We always knew that this was not just going to go away. There was always going to be challenges, and there was absolutely no way that Facebook was ever going to lie down and just accept the decision and walk away from being able to transfer data into the US. Up until now, it has been pretty quiet. There's been a huge amount of commentary, but we've not really heard anything from Facebook on the issue. This is until earlier this week, when a blog post by Nick Clegg, the head of regulatory affairs for Facebook Ireland, stated that they believe that the standard contractual clauses were in fact still validated under the original Schrems II ruling, and that they have decided to take the DPC, so the Irish Data Protection Commissioner, to the High Court to challenge the latest preliminary order from them to stop Facebook transferring data from the US to the EU. And where does this come from? So let's go back slightly, back to the original ruling, which has been digested, commented on, and a lot of people have been through it in very fine detail. Now, one of the things that came out from that, and one of the things that Noib, Max Schrems and Alexander Hanf and the like were very keen to point out in the aftermath, was that the ruling was also very clear that the use of standard contractual clauses by organisations such as Facebook, so companies providing information societal services who are likely to be subject to greater levels of surveillance in the US because of the way the US consumes that information of their surveillance program, would not be able to rely on standard contractual clauses for continued transfers of data from the EU to the US. The reason for this is fairly simple, because standard contractual clauses require the company receiving the information to agree that they were going to abide essentially by European law. Privacy Shield has already demonstrated, or the pull down of Privacy Shield has already demonstrated that that isn't possible. So just because you've got it written in contractual clauses doesn't mean that it's going to happen, and therefore those clauses cannot be validated for certain organisations. But on the other hand, are adamant, it seems, that this is still permitted and this is what they want to do. Now, there has been a initial preliminary ruling from the Data Protection Commissioner in Ireland to Facebook to order them to cease the transfer of EU data, so EU data collected on Facebook, to the US. Now, this is a fairly serious problem for an organisation like Facebook, who are going to struggle to work out how to apportion that data, how to find that data of all European citizens, and then keep it wholly within a European data centre. I don't think it's undoable, but I do think it's going to be costly, and it's something that they're going to not want to have to put their money into. So this is what is being challenged, and it's now going to be challenged by Facebook Ireland in the High Court on the basis that standard contractual clauses were not invalidated during the original Schrems II ruling, which, from what I've seen, is not entirely correct. Now, there are two things here that particularly interest me about this story. The first thing is that Facebook, Twitter, and a number of other high-profile data-led organisations have purposely picked to base themselves and their head office locations in Dublin, in Ireland, and it's always been said that that was done because historically the Data Protection Commissioner there has been a lot more lax and is a lot more commercially friendly more likely to allow organisations or large organisations to do more things without particularly paying too much attention or going after them without good reason. So that was the reason why Facebook put their head office in Dublin. It's interesting that now the place where they thought they were safe is actually the place where the Commissioner is deciding to bare their teeth. The other thing that interests me about this particular case is that under obviously the regulation, there is always talk about how much a fine could be if a fine was levied against an organisation for a breach. Now, as we know, there are 2 tiers of fine. So the first tier is for administrative fines and the second tier is for breaches. Now, within those fining regimes, there are a number of criteria that have to be met before you can get anywhere near the top tier of fines. But some of the criteria within that are knowingly breaching the regulation, ignoring a regulator when they come to you to question you or provide for assistance, or unnecessarily challenging them over an incident or a breach. So it is entirely possible that if the Data Protection Commissioner has instructed Facebook to not transfer EU data to the US and they do not comply, that they could be subject to the top level of fine, which in this instance could be billions, simply on the basis that they are knowingly carrying out a transfer which has deemed to be in direct breach of the GDPR. So there'll be an administrative fine and also a fine in terms of the breach, which is going to take them up through the tiers. So it could be massive. What's most likely? In my view, I think what's most likely is that Facebook are going to take this opportunity to drag this out as far as they possibly can and for as long as they possibly can. It's important to point out that it is a preliminary ruling from the DPC to Facebook, so they have the opportunity to challenge it, which is exactly what they're going to do. By taking that challenge to the High Court, you're instantly adding on time. This is not going to be resolved by next Friday. This is going to take some serious legal wrangling, and this is where we're really going to see the power of Facebook as an organisation and the power and the money and the access to what and who they have to be able to drive their point across against a controlling data protection regulator who, while they are trying to bare their teeth, I don't think they're going to have the legal support and the financing to possibly be able to take on what is actually going to be a very, very politically driven case. It is going to be really fascinating. As I say, I don't think we're going to have any answers anytime soon, but I am very much looking forward to seeing how this works out, because this is going to have a huge effect on data transfers moving forwards for a lot of organisations, but I also think it's going to have a huge effect on how organisations look to Dublin and Ireland as a base, as a safe haven for international data transfers, and looking at it having a safe regulator. So it's going to be an interesting story. Obviously, as soon as we know more, we'll be back to give you a brief update. As always, if you find these videos useful, if you find them interesting, please do give us a like, comment and subscribe to the channel as well. It really helps us just to reach more people, and it shows that this is worth doing. But for today and for now, that's it from us. We're out. We look forward to speaking to you again soon. Thanks very much.